So I would like to start off with the terms and conditions of the employment relationship. And what is an employment agreement? So an employment agreement is a relationship between an employer and an employee. And there are three parts it has to consist of. One is that the employee or the individual actually performs work for the company. The second is that the employee, the individual, receives a remuneration for it. That can be salary, but it could also, for example, just be housing costs, or doesn't have to be money. And the third one is that it is a very important point, is that the individual is under authority of the company. So the company can actually give directions to the employee what the employee is supposed to do. The third point is very important, because if you lack that third point, it would rather be a contractor's agreement. So someone, a more individual person who performs work for the company, does also receive reimbursement for it, but has more, is not under that authority. So that is a very important difference. And there are lots of different types of employment agreements. You have a 0-hour contract or a min-max contract, that an employee works minimum of 10 hours, maximum of 40 hours. But for this seminar, because we have to keep it in a nutshell, we only focus on the employment agreement, just like a full-time employee, 40 hours, 36 hours, 32 hours. And an employment relationship is regulated by various legislation, for example. That is the most important one. Most of the important legislation is regulated in Book 7 of the Code of Conduct. But there are lots of other acts that need to be taken into consideration, like Minimum Wage Act, Working Conditions Act. So please keep in mind that the different regulations can be found in different acts. We won't go through all of them at this moment, but it is important to know that you have to look at a broader scope than just Book 7. Then a collective labor agreement, if applicable, could also regulate the terms and conditions of an employment agreement. We will go into a collective labor agreement a little bit further on, but keep that in mind, that legislation rules everything. Then collective labor agreement could rule certain terms and conditions, because the legislation in some situations gives the collective labor agreement a possibility to deviate from the legislation. So if a CLA is applicable, also look at the CLA. And then the third one is that some terms and conditions can be agreed upon between the employee and the employer, and have them agreed upon in the employment agreement. So the height of the salary, for example, is an important one, if someone is getting a car benefit or commute costs. So there are certain things that you're free to decide on what to give the employee, but always check that it's not in conflict with legislation, or if applicable, a CLA. Another important thing is that if you have a bigger company, more employees, that the employees are provided with the same terms and conditions. And of course, not everyone has to get the same salary, but it's not possible to give someone 30 vacation days and someone 12. So there needs to be equal treatment in the broad sense of the terms and conditions. So a collective labor agreement, we could spend an entire seminar on a collective labor agreement. We're not going to do that, but I do want to highlight what it is. So a collective labor agreement is an agreement concluded sometimes between a company, but most often by an employer's organization and an employee's organization or a union. And those two parties discuss and agree upon an overall collective labor agreement that covers an entire sector. Market sector. For example, if you're a company and you are a wholesale of textile goods and you have a B2B, then the CLA of wholesale textile could be applicable on the company. So what do you check to see if a CLA is applicable? Well, that is, first you go to the scope of the CLA. So the scope describes which companies or which activities of companies fall underneath that collective labor agreement. So if the activities of your company fall under the scope, that will be the first check. After that, you have to check if you also have to apply those terms and conditions to your employees. And you only have to do that either if you're, as a company, a member of an employer's organization, and I expect that none of you are, or if the CLA has been declared generally binding. And if it's been declared generally binding, there's nothing you can do except for apply that CLA. A generally binding CLA is usually for a duration of 2 years. So when it ends, you can then again apply other terms and conditions. But the moment a new CLA has been agreed upon and is generally binding again, you will need to apply it. So it's important to just keep this in the back of your mind. We always do a CLA check when new companies become a client, but sometimes during the course of the events, the activities expand, and it might be the case that at a later point, the company does fall under an applicable CLA. The employment agreement itself. It is a relationship that can be agreed upon verbally. So if you talk to someone and you tell them, okay, tomorrow you can start working and you will get this salary, and this person starts working the day after, an employment agreement is there. So it's very important to remember that if you really want to make sure that all the agreed upon terms and conditions are clear for both parties, is to actually have it in an employment agreement. So it's not an obligation, but it is a very advisable step to take. And on top of that, there are a couple of clauses, such as the probationary period clause and the non-competition clause, that are not even valid if they are not agreed upon in writing. And the first one, fixed term employment clause, you can have a fixed term employment clause verbally, but there could easily be discussion about it. So if someone starts on a verbal agreement and later you say, no, it was meant to be for 1 year, prove it. So please always take that clause into consideration as well. And never have an employee actually start working without there being an employment agreement in place. That would be our advice.